Hi, good morning everybody. My name is Luke Graham. I'm a lecturer in public law and human rights in the law school, and it's my pleasure today to chair today's first panel on the Global South. So we have a really interesting, diverse lineup. We have my colleague in law, Yusra Suedi, who will be joining us via Zoom today. She'll be speaking on barriers that we may face in litigating climate action within the African human rights and legal system. We then have Gloria Munoz, who will be speaking about barriers to individual participation in climate transition and climate action, and so forth, particularly barriers for individuals based in the Global South, individuals experiencing poverty, and so forth. And then finally, we have, I'll just check my pronunciation of the surname, apologies, Chris. So we have Chris Kinali, who will be really speaking very broadly, not very broadly, very narrowly, but in the broadest sense, about what I see, something that comes up quite often, a tension between sustainable solutions and then some of the negative impacts of those solutions. So in particular, the waste and the damage that is created by batteries and solar power and so forth, whether they, through life cycle assessment, they actually do have a positive net gain or not, in the simplest sense. So each speaker has roughly 20 minutes. Within that time, there will hopefully be time for questions from the audience as well. But if the speaker runs over, it may be that we don't necessarily have the time to do that, and we will try and keep to the 20 minutes as strictly as possible. In terms of the Zoom and joining us.
Okay, good morning everyone. I trust that you can now hear and see me. Unfortunately, I don't think I'm able to see nor hear you at the moment. Hopefully that can be resolved, but nonetheless, I do want to thank the University of Manchester for the organization of this conference, and more relevantly for allowing me to participate. I'm very sorry that I can't be there with you in person this morning. I've actually just had an operation, and so I'm in recovery, but thanks to the magic of the internet, I can still be with you and present some of my thoughts for what is a really important conversation to have in the context of this panel and this conference. So what I'd like to discuss with you this morning is climate change litigation before the African human rights system. And so just to contextualize where this fits in this panel, which is talking about the Global South and the climate context. Well, first of all, this research that I'm going to present to you this morning actually stems from a journal article that came out earlier this year, written by myself and a colleague from the University of Geneva, where I used to work, called Marie. And I've put the link if you'd be interested in following up after this presentation. So let's contextualize how this fits into what we're talking about today. The facts are that the African continent is distinctly vulnerable to climate harm. That's just a reality that I feel not enough attention, I would say, is actually shed on this in mainstream media. Although at the COP28 that's currently taking place in Dubai, I appreciate that there is a lot of due emphasis on this. So science has told us that in the coming years, Africa will essentially be extremely disproportionate in carrying the impact of climate change. And so the Intergovernmental Panel on Climate Change has made this very clear in its latest report. And we can imagine and foresee things such as sea level rise, flooding, especially with respect to coastal cities in East and West Africa, along the Nile Delta. We can imagine drought, right? We can also imagine a lot of impact when it comes to agriculture, loss in agriculture. This will definitely heighten issues of famine and migration, and that has also been spoken about by the FAO, the Food and Agricultural Organization of the UN. So we know that climate change can bear, significant impacts on the African continent. What we also know is that there is a huge global trend in climate change litigation at the moment, and that is worldwide. So there's an excellent report that I have included here, which has diligently been prepared by the London School of Economics, also where I used to work, where we really have the breakdown of all the kind of cases and countries and ways that climate litigation is coming up. And this has also been really wonderfully work done by the Sabin Center at Columbia University. So on this little image that I've shown, you can see the types of lawsuits that have been brought domestically against governments on one hand, and then against corporations and individuals on the other hand, and the types of issues that have been raised. So whether it's about protecting biodiversity specifically, or whether it's about just transition or human rights, right? So you see that there have been a significant number of cases about human rights and about GHG emissions, for example. So we do have an incredible and ever-growing trend. But more relevantly for my research, there is also a trend in international climate litigation. So beyond domestic courts, we also have international courts, right? That were established to resolve disputes that go beyond domestic laws in specific countries. So we have courts in the international system that resolve disputes between countries, right? So Switzerland versus France, they might have a dispute about something, for example. So we have the International Court of Justice. That's a court based in The Hague and will typically deal with all international law issues between countries. And that is the principal judicial organ of the UN. We also have the International Tribunal for the Law of the Sea. That is a tribunal established in Hamburg. And it's an interstate court, so also dealing with the Switzerland versus France type cases, so state versus state, but really specifically on law of the sea matters, regulated by a multilateral treaty that deals with issues about the law of the sea. And then on the other hand, we also have a bunch of regional courts that deal with disputes between individuals and states, because they are essentially human rights courts, right? So individuals such as ourselves can sue the nation states, the states of which we are citizens, before a regional body and say, hey, you know what, my government is not respecting my human rights, and that's why I've come to you to kind of put them in place, essentially. So we have 3 regions where this is covered. We have the Inter-American Court of Human Rights, we have the European Court of Human Rights, and then we have the African Court on Human and People's Rights. So just to show this to you on a little map, we have the European Court obviously is above, and then we have the Inter-American Court on the left-hand side in Central America, and then we have our African Court. And so these are the 3 courts that we have to really cover human rights issues on the regional level where countries actually fail to respect human rights obligations. And so obviously, given this context that I've presented, the question that we can ask at this juncture is, what about the African Court on Human and People's Rights? What does that court have to say, or what could it say? How could it be involved in ensuring that states on the African continent are climate aware and that they're switched on and really respecting their climate obligations, and that they're part of this wider global conversation about climate harm? And this question is important because all the other courts that I have just spoken about have been seized and are currently dealing with a climate change case. So the International Court of Justice has before it an advisory opinion, a request, and I'll come to exactly what that means, but essentially there is a case before it where it's answering very big, significant questions about climate. The International Tribunal for the Law of the Sea, exactly the same thing. At the moment, hearings have already taken place in September. And then the Inter-American Court, same. The European Court of Human Rights, same. And in all of these 4 courts, there has been so much flurry and activity in the last couple of months. So for my research area and people in this area and also practitioners, this has been a really exciting and very busy time. However, I cannot help but notice that the African Court on Human and People's Rights has yet to actually enter this conversation and really, be a part of this movement and what's happening. So before I go any further, it's probably important to tell you a little bit about the African Court. So it was established in 2004, and what it does is that it will protect human rights that are enshrined in the African Charter on Human and People's Rights, essentially. So this is a regional treaty that has been signed and ratified by African nations, and it states that these are the human rights that we have to respect in our countries, and the court is there to kind of ensure that that is respected. It's also there to interpret those provisions and to attempt to enforce such provisions. It has 34 states parties, and then in terms of the types of cases it can deal with, and this becomes really important for the rest of my presentation, it can resolve disputes on one hand where individuals or NGOs sue states. So we, for example, if I were a citizen in the country of origin, my country of origin, which is Tanzania, then I could sue Tanzania before the African Court on Human and People's Rights if I considered that Tanzania had violated my human rights as a citizen. So that's an example. And then they can also give advisory opinions. And that means that there's not necessarily a dispute between one party and another party, but we might just have a question, a general legal question that we want to ask, like, hey, can you help us understand this? Can you help us understand what climate obligations might look like for African countries? That might typically be a question that it could ask, right? It's a very general question. And so it's not resolving a dispute, it's giving an opinion, okay? So these are essentially the 2 types of things that this court can do. And so when we're looking at whether, the court could enter this conversation, there are 2 ways that it could do that. The first is essentially by being sued. If it's sued and it has to actually resolve a dispute, and that dispute is about climate, then there you go, it's in the conversation. Now, there are some potential problems that in this article I have flagged, okay, and that I foresee happening. The first one is about exhausting domestic remedies, and the second is about victimhood. So I'll get to exactly what that means. Exhausting domestic remedies is that basically before I, as a Tanzanian citizen, go to the African court, I have to have sued, gone to the highest Tanzanian domestic court first. So the state has to have the opportunity to resolve the issue domestically before anybody can go to a regional human rights court, right? And the issue is that in a lot of these cases that have been coming up before the European Court of Human Rights, for example, individuals have been skipping that stage because they're like, look, we're in a climate emergency. We don't really have the time to go to a domestic court. We need to act now and go to an international court. States have had loads of opportunities to kind of, respect their obligations. They haven't really been doing that. So we just need to act quickly, okay? And unfortunately, in other instances where that has happened, those courts have kind of been like, well, listen, I get that the climate emergency is important, but rules are rules, procedure is procedure, and we can't actually just kind of ignore the requirement to exhaust domestic remedies. So you still have to do that. Go home and do that. When you've sufficiently done that, then you can come back to us, right? So this has been raised in other cases. And that makes me think that if a case were to come up before the African court, I don't think this would be wavered because of, the climate emergency. And that means that it might take time. And so that's something to kind of consider on the basis of case law elsewhere. And then the second issue, which might be a bit tricky, is victimhood. So when you show up, you have to show that you essentially have kind of a connection and a reason to show up. You have a reason to stand as a party. So you have to basically demonstrate a couple of things that are really based in science, so that the state, so Tanzania in my case, has, their inaction has contributed to climate change, but also that there is a relationship between the climate harm that has been happening and the violation of my human rights. So for example, my right to food or my living situation or my right to life has been, endangered because of climate change, and climate change has been caused because of a state that hasn't done this or has done that. Okay, so there are two elements of that causal link to establish. It's very clear these days that the science has really backed up, and different other courts as well have backed up the fact that there is such a connection. So that shouldn't be complicated. And actually, before the African court, it's okay to show up on behalf of a wider community, so for a public, and to kind of be reflecting collective harm. So that's wonderful, because there are other regional courts where you can't do that. And that's very limiting, right? So this is actually a lot more promising and a lot better. And then in terms of public interest litigation, you can also show up even though you are not a victim and you are representing a bunch of other people who are victims. So that gives a lot of flexibility in terms of victimhood, which is great. Now, turning to the issue of advisory opinions and whether an advisory opinion can be requested, essentially the two problems here are who is making the request for the opinion, and maybe the fact that those opinions are not actually binding, which I didn't mention earlier. So in terms of who makes the request, what's really great before the African court is that NGOs can make a request. So that's great, because other regional courts don't have that actually. It's only states who can make requests, right? So we can, ask the questions that need to be asked, for example, about climate change. But the problem is that the African court has hardly, done that, because a lot of NGOs have brought up cases and then they've been deemed not eligible because they haven't met certain criteria that is listed on the screen. Basically, there are lots of different there's a bit of a checkbox exercise. You have to be this type of NGO, that type of NGO. The information is not very clear. So that has been a problem in the practice. And then with regards to the nature of the outcome, advisory opinions are not actually binding. Unlike the other, the contentious cases where you have a judgment that's come out and it's resolving a dispute between two states. Those are binding on the parties. But advisory opinions are just opinions, so they're not actually binding. And so you can ask the question like, well, what's really the point, But I think that advisory opinions are still authoritative decisions. They still influence domestic law and policy making. Have been examples where they have added to the pressure to result in compliance. And more importantly, they reflect this idea of strategic litigation where you're really kind of protesting and putting pressure as opposed to focusing on winning and producing something binding. So essentially, my assessment in this piece is that I think that the African court could be a very promising venue because of the different elements that I saw that either can be circumvented or are very positively kind of positioned to assist in these cases. I'm really looking forward to receiving questions, and thank you so much for your time and for allowing me to participate.
Natalie's going to bring over it so you can talk to her on that laptop.
Yeah, so hopefully you can... Hi, thank you so much.
Yes.
Okay, thank you so much. So Yusra, we're in a situation whereby whilst I speak, you won't be able to speak because there's feedback in the room, if that makes sense. But very much enjoyed your presentation, and we have a few minutes for questions now. Obviously, we have gone over the time side due to technical issues at the beginning, but there's still about 3 minutes of your 20 allotted minutes to go. So what I suggest is that we take a question in the room. It may be that you can't hear them because I'm holding a laptop at the front, but as you can see, a full room, and you have rapturous applause at the end of your talk. It's wonderful. So if there are any questions, please, you can introduce yourself, and I may repeat your question if it's not heard. Okay. Any hands? So there's a hand at the front.
Yeah, I don't know if you can hear me, but I guess my question is about, there are lots of human rights challenges in Africa. And so how do you see the prioritization with the contextualization of all of those different human rights challenges in terms of justice with climate, right? So because climate is more people, should we be focusing more on that? And how is that balanced? Because of course, I think it's a court which needs a lot more cases coming to it for a lot of different reasons.
Okay, so we are just about to unmute you now.
Can I speak? Yeah, okay, great. Thank you so much for that question. Well, so I understood I maybe understood two aspects of the question. I'm not sure which one hits the nail on the head, but I think that for a long time, maybe a reason why there was little prioritization is because I agree with you that there are lots of human rights, there are lots of human rights perspective violations, there are lots of issues on the African continent. But I do think that the scholarship and policy work has increasingly shown the nexus between all the other human rights issues that could be, happening or are happening on the African continent and climate change, and how essentially there is a very strong correlation between one and the other, and how the climate emergency can essentially worsen all of these issues. So because of this momentum internationally about climate change, actually a focus on climate change could also allow for some of all of these primary human rights issues to actually be, to some degree maybe taken, more seriously, or maybe expedited even, right? And maybe the outcomes that we find in the climate context can actually shed light and develop the case law on, the basic human rights outside of the climate context. So I do think that this nexus could be really positive and could be capitalized in this context. So there should be a prioritization, in my view. Excuse me. I hope I answered that question.
Yeah, you have a thumbs up. So thank you so much, Yusra. Yeah, you had a thumbs up in the room. A really great question, really wonderful response as well. We do have to move on to our next speaker now, just to ensure we keep to time, but I hope you'll be staying, and we'll make sure that obviously you can join the panel discussion as well with the tech and make sure it works properly. So with that, do we have Gloria in the room, or is Gloria?
We do.
Yeah, here we go. Wonderful. Thank you so much. So it's my pleasure then to introduce